Right out of the gate, the defense attorney taps out, and that alone tells you everything about the storm ahead. When your own lawyer says, "I can't help this guy," it's not strategy, it's surrender. The defendant doesn't realize that legal representation isn't a threat to his voice. It's protection from his own lack of understanding. Instead of seeing a lifeline, he sees interference. That mindset sets the tone for everything that follows, and none of it goes well.
Your Honor, James Kazicki, I'm asking the court right now if I could withdraw on this matter. I don't think I could adequately help Mr. Lanto in his legal arguments because I'm not familiar with the issues in it. And I'm just asking the court if I can.
Here comes the classic contradiction, wanting to be left alone while actively engaging in behavior that invites legal scrutiny. You can't walk into public spaces, challenge authority, and then claim victimhood when consequences show up. The irony is thick. The court isn't chasing him. His actions brought him there. Freedom doesn't mean immunity. And this misunderstanding is about to derail every opportunity he has to resolve this cleanly.
And Mr. Lanto, then I can appoint a different court-appointed attorney.
Well, I just want to clarify and make sure I'm going to be able to speak for myself in the court. I don't want anybody speaking for me. As a matter of fact, I mean, all I really want is to be...
The recording argument kicks in, and it's a familiar tactic, manufacturing distrust to justify control. The judge calmly explains that proceedings are already recorded, offering transparency through official channels. But instead of accepting that, the defendant leans into paranoia. Courts operate on procedure, not personal comfort. If every individual dictated rules based on feeling safe, the system would collapse into chaos instantly.
And then as far as an audio-only recording, I was told that there's an objection to the audio-only recording, and I'd like to know, I don't feel safe without a recording, so is there any reasonable objection?
Well, first off, you can't record in the courts of law. If you'd like a transcript, everything is already being recorded by my court recorder, and I can assure you that there's no, the recording device is on and it records, and that's what she does. She records everything. So if you'd like a transcript of that after the proceedings, you're more than welcome to order a transcript. So
I've been told that before, and then when it comes to getting the transcripts, I still am waiting for the transcripts when I was told that in the past. So well, like I said, I don't feel safe without a report.
I know that you're not talking about the 23rd District Court, because I know if you've ordered a transcript from my court, those are always forthcoming. I've never had to deny anybody a transcript. So if that happened to you in another court, then I suggest that you call the State Bar of Michigan and report that court, because obviously they're not doing things correctly.
I have no desire to do that. All I want is to have fair and meaningful hearings. And first off, I'd simply just like to be left alone. But other than that, to get fair and...
I get that, but obviously you had an interaction with somebody where they are alleging that, because today's the date and time set for the arraignment. So I want to make sure that you understand, I need to phone. On the date and time in question, it is alleged that, because first let me do the arraignment part, because I need to let you know what exactly you're being charged with, all right? So you say you want to be left alone, but they are claiming that there was an interaction. Now, first off, you do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney if you got a 411 will be appointed to you by the court at public expense. Now, it is alleged that on November the 17th of 2022, while in the city of Taylor, that you violated City Ordinance 32-31, which is a charge commonly known as interfering with the police authority. That is a misdemeanor punishable by 93 days in jail and or up to $500 in fines. So, as to that charge, how do you plead? Guilty or not guilty?
Now the judge does exactly what the system requires, lays out the charge clearly and formally. It's straightforward, procedural, and necessary. But instead of absorbing the information, the defendant gets stuck on semantics and suspicion. And this is where many self-represented individuals fail. They confuse clarity with conspiracy. The court isn't hiding anything. It's literally spelling it out step by step.
I just make a few clarifications.
I'm going to caution you that anything you say can and will be used against you. So
I understand.
As to guilty or not guilty, that's just the only question I'm asking right now.
Well, in order to say guilty or not guilty,
or you can stand mute, which means I'm not saying anything, and then I will enter a plea of not guilty for you, so that you don't have to say anything, and it automatically goes to not guilty. So are you pleading guilty, not guilty, or standing mute?
Well, before I make a plea, you stated that I have the right to be informed of the cause.
The plea moment arrives. Simple, direct, and unavoidable. Guilty, not guilty, or silence. That's it. But instead of answering, he tries to redirect the process. This is the legal equivalent of refusing to press start on a machine while complaining it's not working. The system can't move forward without that input, and delaying it only weakens his own position.
What I just told you. I just told you what the charge was.
Okay, and you're stating that it's based on an interaction. So my guess is that you have no firsthand knowledge of anything that happened?
Well, I'm not stating anything. All I'm telling you is what the people of the city of Taylor have charged you with. They have charged you with a violation of City Ordinance 32-31. And that ordinance is commonly known as, by name, as interfering with police authority. I'm not putting any allegations. I'm not stating any facts. I'm merely stating what has happened to get this case into my courtroom. That's it.
But you sound awfully fair to this point, and I certainly appreciate that. Because, yeah, and just to be specific, it's not the people of the city of Taylor, it's David Jones, and then I don't know the name of the prosecutor, and I just want to make sure that the prosecutor is aware of, Section 241, Section 242, Title 18, deprivation of rights under color of law.
The judge even offers an out, standing mute, which automatically protects his rights. It's practically foolproof. Yet somehow, even that becomes complicated. The defendant treats a basic procedural step like a negotiation, but courtrooms aren't debate clubs. They're structured environments. When you ignore structure, you don't gain control, you lose it.
That's a separate, what you're talking about is civil type cases.
Well, it's also criminal.
So what I'm saying is, in this matter, the matter that is before me, okay, is a misdemeanor matter where it is alleged that you violated an ordinance of the city of Taylor. The people of the city of Taylor, through their attorney, have acted to bring a case against you. So the only thing I can do right now is ask you, are you pleading guilty, not guilty, or standing mute?
Can I have the name of that prosecutor that's bringing the charges? Because I've had in another case where a prosecutor stated at 3 proceedings away from the arraignment, she stated that after reviewing the video...
So, sir, I'm going to take your response as being non-responsive, which is
well, I object to that.
Do with being guilty or not guilty, so I'm going to enter a plea of not guilty for you.
I object to that.
Now he pivots to questioning the judge's knowledge and role, implying bias without evidence. This is a dangerous move. Judges don't argue facts at arraignment. They manage process. By trying to challenge authority prematurely, he's burning credibility before the case even begins. And credibility, once lost, is nearly impossible to recover in court.
Then are you guilty or not guilty? Or standing mute? Those are the 3 things we got going on right now.
Well, I first have to clarify. You did say that I was presuming...
I don't have to clarify anything, sir. I'm being very fair with you. And right now, you're basically splitting legal hairs. Right now, the only thing that I have jurisdiction over is to do an arraignment. Nothing more can happen in this case until the arraignment happens. And the arraignment is whether or not you plead guilty or not guilty. And if you're unresponsive to that question, then I'm going to enter a plea of not guilty for you so that I can protect your constitutional rights, because a lot of people don't know that they should. So that's why I enter a plea of not guilty for people who don't really know how to answer the question. So that way they're not getting, no one's going to be bamboozled or said that, well, you said guilty and you didn't know what was going on. I don't want that to happen. I say that you're either going to plead guilty, not guilty. If someone is unresponsive to that question, then I automatically just enter a plea of not guilty for them so that they can preserve all of their rights to a trial and everything else without having been forced to be pleading guilty. So by you saying everything else, that's all well and good, but it's not the time and place for it. See, that's the problem, is there's a time and place for everything in the matter of procedures of courts. And when you just start trying to jump the gun and go right from 0 to 60, that's not how it works. There's a stepping process, and everything has to go in that process. And the process today is an arraignment. It's just an arraignment where I'm telling the individual who is alleged to be a defendant what the allegations are. And the allegation is that you violated a city ordinance, and that city ordinance is basically one commonly known as interfering with the police authority. So that's and letting you know what the charge is, and letting you know what the penalty for it is. And I've already stated. So again, I'm going to ask you, guilty or not guilty?
Well, I certainly appreciate the explanation. It seemed like
The federal law references come flying in. Sections, codes, accusations. It sounds impressive, but it's misplaced. The judge calmly clarifies jurisdiction, reminding him that not every legal concept applies everywhere. Throwing around statutes without context doesn't strengthen an argument. It exposes misunderstanding. Legal knowledge isn't about memorizing numbers. It's about applying them correctly.
Sure, but I'm literally stating that nobody's trying to bamboozle you or anything like that. I don't know what happened in some other court, and everything that you want to do, you can still do. I just need to know if you're pleading guilty or not guilty. And if you're not answering that question, then I'll enter a plea of not guilty for you, so that it preserves all of your constitutional rights and the case still moves forward.
Right. You said we're interested in preserving my constitutional rights, correct?
That is correct. That is correct.
And then one of those.
What I'm saying is everything that you're saying can be used against you. If you think that you have a motion to dismiss, that's something that you can do, but that's when the case is already going to the next stage, which is
well, like I said,
of not guilty for you.
Well, like I said, I would just prefer to be left alone and not have to come back at all. And then if we're not going to do that, then I definitely like to have fair and meaningful hearings. And my concern is we've got a police officer and we've got a prosecutor, both are state actors, and they're trying to bring charges against me. And I just want to know, because you are a judge.
At this point, the judge has had enough of the circular responses and enters a not guilty plea to keep things moving. Ironically, this protects the defendant more than his own actions do. Yet he objects. This is the paradox, fighting the very mechanism designed to safeguard your rights. It's like rejecting a seatbelt during a crash.
Copy of my, sir, please. I have not cut you off at any point. Please don't cut me off. This is a copy of my oath of office. And why do I keep it here? Because it constantly reminds me that what am I going to do? I do solemnly swear that I will support the Constitution of the United States and the Constitution of this state, and that I will faithfully discharge the duties of the office. So I take that very seriously. My son serves in the Marines. He takes his duty to uphold the Constitution seriously. So if you are implying that I am not going to uphold the Constitution, or that I am going to take an oath and not be true to my oath, then I take offense to it. So if you sense any sort of anger, there's no anger. The only thing I'm telling you is that you are implying that I somehow am an oath breaker, and I am.
Well, not. I didn't. I didn't.
That's exactly what. I swore an oath to the Constitution that I put my hand on the Bible and swore to, and I'm telling you, I don't break my oath.
Okay,
so
would you agree
that implying that you're not going to get a fair hearing? That's my job, is to make sure that fairness happens, that due process happens, and so So I'm asking you, just as a matter of course, because this is the stage that we're at, is an arraignment. Are you pleading guilty or not guilty?
Well, you just said.
Or if you're not responding to that question, I'm going to enter a plea of not guilty on your behalf, and I'll find you standing mute to the question.
Well, I object to anybody making a plea on my behalf, and I just wanted.
I'm not making a plea. I'm just finding you. I'm just entering. I'm just saying that you are right now presumed not to be guilty, because that's just your constitutional right to be presumed not guilty.
And then that means
your constitutional right. I'm not entering a plea for you. I'm just listing you as somebody who is right now not guilty, because the Constitution says you are to be presumed not guilty until proven guilty beyond a reasonable doubt. So I'm not entering a plea for you. I am just merely stating that this individual is to be treated as someone who is not guilty.
Okay, and then, so if I'm presumed innocent of all the elements of the charge, correct?
No, you are presumed innocent until proven guilty. And you haven't had a trial yet. That's your other constitutional right. So if you'd like to set this for a trial, we can just set this for a trial.
Well, we just said that I'm presumed innocent until proven guilty, and then my question was, am I presumed innocent of all the elements of the charge? And
The judge explains the process patiently, emphasizing timing and sequence. Legal proceedings are like steps on a ladder. You can't skip to the top. But the defendant keeps trying to jump ahead, demanding outcomes before foundations are set. This impatience doesn't speed things up. It stalls everything.
I'm not going to give legal advice because that would be more legal advice that you would talk about with your attorney. And when I'm wearing the robes, I can't give legal advice to either side. I'm more like a referee. I can throw a penalty flag, I can call a whistle for a violation of a rule that I see one side doing or the other side doing, but I can't coach either team.
Well, I certainly appreciate you being fair. Yeah, because
the answer to your question is I can't answer your question because that would then be giving you legal advice, and I'm not allowed to give either side legal advice.
Okay, because in this particular case, there are crimes that occurred, but the crimes that occurred were the people that put their hands on somebody that had no desire to be having somebody put their hands on them, and then binding them, and then placing them in the back of a gang mobile, and then taking them to a cage. That's the victim in this case. And the victim,
Okay,
if the victim is going to be the city of Taylor, and it's going to be presided over by a judge that is paid by the city of Taylor with a police officer that's bringing the charges with the help of an attorney, and then they don't know what 241 or section 241 title 18 conspiracy to violate my rights, then I have serious concerns for the fairness and
Accusing the judge of anger is a deflection tactic, not observation. The judge remains composed, but the defendant attempts to shift focus away from his own non-compliance. It's a psychological move. If authority looks emotional, it appears less legitimate. But here, it falls flat. Calm authority always wins over chaotic resistance.
It's located in the city of Taylor, but I don't work for the city of Taylor.
But do you see my concern for my safety?
I absolutely, except for the fact is, I'm presiding over the whole case. And I'm going to make sure everybody has due process. Everybody has the same fairness to bring their case and to make sure that they can cross-examine witnesses and make sure everything is reported by my recorder, who also has sworn an oath, and I find her to have never have broken her oath either. And so I'm just telling you, I'm going to be doing my job, and my job is to defend the Constitution, and I will be doing so. So as of today, it was set for arraignment. I have entered a not guilty as to the charges against you. And right now, I can do one of two things. One, I can set this up for a pretrial. The pretrial is something that I always afford the parties where they can talk to one another. If they want to work something out, I have no problem with the constitutional right to enter into contracts and to do things like that. Or I can just set up for a jury trial or bench trial right now. If you want to forego any of that and say, look, I really have nothing to discuss with them, I'll just like to go to trial. So would you like to meet with the prosecutor? Well, in which case I will set this up for a settlement conference date where the two of you can discuss the matter. Or I can just set this for a jury trial or bench trial right now.
Well, I mean, I do have a couple objections to that because I'm being labeled and called the defendant here.
The "I just want to be left alone" line returns, but now it's even weaker. The court has already explained why he's there. Repeating the same claim doesn't change reality. It just highlights refusal to engage with it. Courts deal in facts, not wishes.
If this is a fair proceeding, then that prosecutor, as long as we're going around and throwing out suspicions and alleging crimes, I'm going to allege them of the crime of the Department of Justice, Section 241, 242, Title 18, which is deprivation of rights under color of law. And I take serious issue with people acting like criminals.
Okay, so what I'm saying is this. One, I don't have jurisdiction to take your case. Two, you're citing to federal law. Three, you would have to file that in the federal court. And and all of those things are available to you. You have the right to do so and have the proper court determine that. All right. So What I'm saying is this is a city ordinance, and I have jurisdiction over state cases and over city cases, misdemeanors, and I don't have, and what you're stating, I don't have the jurisdiction to hear. That doesn't mean that you can't bring that case in the proper court. All I'm saying is from now on, I'm just going to refer to you as Mr. Lanto. If you prefer not to be referred to as the defendant, then I'll refer to you as Mr. Lanto. The prosecutor is Mr. Dave Greco, and I'll refer to him as Mr. Greco. And that way, everyone will just refer to one another in their generally names. But what I'm asking you right now is, would you like me to set this for a settlement conference at a later date, or would you like to set this for a bench or jury trial?
Well, I'm willing to forego any intention of criminal charge.
Now he questions fairness, hinting at systemic bias. The judge responds firmly, even referencing his oath. This is a critical moment. Judges don't take accusations of dishonesty lightly. The defendant crosses from confusion into confrontation, and that shift raises the stakes significantly.
I'm going to give everybody the opportunity to look at the case and think about it, and not have to. I made sure that you didn't have to take a guilty plea right off the cuff without having to think about it. So I'll set this for a settlement conference. Settlement conference, and everyone can come back at that settlement conference. And if there's if there's a resolution, then there's a resolution. If there's not a resolution, then I'll ask if you want a bench trial or jury trial, because that's your constitutional right, and I just need to know which one you're choosing. So, all right?
Outstanding, because I'd like to talk to this prosecutor.
The presumption of innocence gets twisted into a philosophical debate. Instead of accepting it as protection, he tries to dissect it beyond relevance. The judge refuses to provide legal advice, reinforcing neutrality. This is a boundary, one the defendant keeps trying to push past unsuccessfully.